to the Catholic Culture Podcast, dedicated to the Holy Family. I'm Thomas V. Miras. Today I'm talking to former Virginia delegate Bob Marshall, who has some very important lessons in practical politics for Christians and other believers in the natural law. Hey everybody, I have to apologize for the lack of episodes the past 2 weeks. I had 2 different interviews that sort of fell through in different ways. At least one of them I got a short article out of, though, that I felt turned out very well. I tried to interview this elderly retired priest who played trombone with Duke Ellington for 5 years, and unfortunately his memory wasn't really good enough to do a podcast episode, but I did get a nice little article out of that, and I'll link to that on the show notes page for today's episode, catholicculture.org/episode 17. And on another note, as always, anybody who wants to give constructive criticism or feedback of any kind or suggestions for people you would like me to consider having on the show, shoot me an email at podcast@catholicculture.org. My guest today is one of the few totally honest men in American politics, former Virginia delegate Bob Marshall. You know, it just occurred to me as I was preparing to record this that if Bob were involved in national politics, he is the type of guy that the Catholics who want to somehow be Catholic and also please the world at the same time would be tripping over themselves to disassociate themselves from him, because he is so completely unapologetic and does not mince words in defending life and defending marriage. The kind of guy that the seamless garment types would be very, very embarrassed by, and that is the type of guy that you want to spend your time with. Now, aside from just not giving a darn what anybody thinks about him, Bob knows an insane amount about American government and law, both the philosophy behind it, the history of it, and the very practical details of it, how it works from his decades in politics. Bob has been good enough to share many of his practical insights into the political process in his new book, which we will be discussing. Aside from that, Bob is an old family friend, so it's kind of cool to have him on the show. Bob Marshall, welcome to the Catholic Culture Podcast.
Well, thank you for having me on.
I was wondering if you could just give us a quick overview of your own political career up to the present day before we start talking about your book.
Okay. First, I worked in Congress for 6 years for one Democrat Farm Labor member, a conservative social Catholic, and then 2 Republicans, one from California and another from Alabama. That was Jeremiah Denton, the prisoner of war, and then Congressman Bob Dornan from Southern California. And Mr. Denton was a senator, first Catholic from Alabama ever, and I think the first Republican since Reconstruction. So I had done that. Additionally, I was elected 13 general elections and 1 primary in the Commonwealth of Virginia to the House of Delegates. And that was in 1991. I won 13 general elections, 1 primary, lost 1 general election last November. So that's kind of the mechanics of the background.
Yeah, your defeat last November was under interesting circumstances. From what I understand, it was sort of the testing ground of a strategy that the Democrats were planning on rolling out on a national level for this November. Is that right?
It worked very well. I was outspent at least 3-1, but I had been outspent before. But the difference this time was my opponent, who's a guy who thinks he's a woman and went to Catholic elementary school in, I guess, St. Bonaventure, was the fact that he had a significant advantage in the number of people who would walk door to door. And to just give you an example, my wife and I were over in a precinct, and a precinct is the smallest election cell in the body politic. There's about 186,000 of them in all 50 states. But anyway, we were over at a precinct near Route 66, and in about 45 minutes, my wife and I ran into 6 individuals with Planned Parenthood shirts on, and the women had those strange hats. And I thought to myself, this is one Saturday, there's 17 precincts times 6. That's over 100 people walking against me. My one problem was I had people who thought that a guy with this kind of background could not possibly win. Well, Hillary Clinton supported that policy, and she won the precinct handily in 2016. So it was a distinct possibility, and I just had a rough time. But anyway, that's how that happened. So there's no big mystery as to how this stuff works. If you get the most people going door to door and just saying, "Hi, could you vote for Sally or Sam?" you're going to increase the voter turnout significantly for your candidate. If you don't do that, you're not going to see that happen. And it just so happened that the pro-abortion, pro-homosexual, pro-unnatural law people just had more, volunteers or paid people, both, going door to door.
Well, we'll definitely return to that aspect of local politics later on in the interview. So we're here to talk about your new book, which is titled, it's from Tan Books, and it's titled Reclaiming the Republic, How Christians and Other Conservatives Can Win Back America. Can you just tell me how this book came to be and sort of give an overview of what you were aiming at in writing it?
Well, it is derived from my, working in Congress for 6 years and then being in the General Assembly for 26 years and seeing what worked, what didn't work, and how the people who favored traditional morality were treated or not treated, and how they succeeded or didn't succeed. So I took notes all this time and decided to put it together so that there would be more informed Christians to run the civic order.
Right. And one of the things distinguishing your book, I think, is its practicality. There's a lot of books coming out these days by Catholic authors on politics and, how Christians can affect the world and, affect the state of the United States. But a lot of them are more philosophical, more ideological in nature. Your book assumes a certain viewpoint for the most part and instead sets out to educate people on the details of the way our system actually works, and then gives a lot of really specific practical advice on affecting things, which I really appreciated because I tend to be philosophy heavy and a little weak on the practical stuff myself.
Well, again, it's like if you have a car that breaks down, you need to know how to diagnose it and how to deploy the tools you have, know what the tools you have to make it start again. So this is the equivalent for the civic order. It's a how-to civics book aimed primarily at Christians because I start off early in the book with the discussion of natural law and the foundational place in American history, law, and government that natural law plays in our government, in the founding, in the Declaration of Independence, and in the Constitution. And the fact that you start with natural law says you don't have to be a Catholic. You could be of any background, but you have to understand that there are certain laws of nature and moral assumptions that are behind how government operates. And if you know that, then you can get somewhere. And again, the fact that I am starting with natural law, people say, well, this is mostly a Catholic kind of interest. That's not correct. There was only one Catholic who signed the Declaration of Independence. He was from Maryland, Charles Carroll. So everybody else was Anglican, Unitarian, evangelical, whatever, but there was only one Catholic. So you can't say this is a, Catholic thing, natural law. It was everybody. Everybody was educated in this classic background, and that was the assumptions. And the founders were willing to put themselves out there and be judged by the standards of natural law in their effort to break from England and establish a new government in the United States.
Well, it's interesting. I've noticed that, and certainly in myself as well, that a lot of Catholics seem to be a little bit cynical at this point about the possibility of changing things through politics. So what would be your sort of briefest argument for why it's too early to give up the hope of changing things via political means?
Well, go back in salvation history, in knowledge and the operation of the government was a necessary condition for those people involved in salvation history. I'll cite you three people. Number one, Joseph, with the coat of many colors. was sold into slavery, but he became the vice regent, the second in command in the kingdom of Egypt. He knew the Egyptian laws inside and out. And it was his knowledge of this which was instrumental in saving the people that were chosen by God to carry the message of one God and an eventual Redeemer. That wasn't direct salvation knowledge, but it was knowledge of how the civic order works. The second person who had a intimate knowledge of the civil order was Moses. Moses was raised in the courts of Pharaoh, and he could go in and talk to Pharaoh. I mean, I just can't go down to Washington, D.C. and knock on the door of the White House and demand to talk to Donald Trump. I just can't do it. But I know of ways to get that done. So you have to have the knowledge of the civic order. And I would suggest to you that's why God picked both of those people for the intricacies and the parts they played in salvation history. And the third one is as explicit as you can get. When St. Paul was having a rough time with the equivalent of the Jewish Senate called the Sanhedrin, they went to Festus, who was the governor of that Roman province down there, and they wanted to take jurisdiction over Paul and stop him from speaking about Christ who was resurrected. And again, this is a civil trial. You wouldn't see this in the United States, but nevertheless, that was going on. So this basically was a First Amendment question. Question being, was the Roman governor going to turn over Paul so that the Jewish government could stop him from speaking? And Paul said, wait a minute, Festus. I mean, obviously he didn't use those words, but he said, look, you cannot turn me over to another jurisdiction which would be in effect claiming superiority to Rome. And this would have been, the death sentence for Festus to do that. And he says, well, why can't I do it? And Paul said, I'm a Roman citizen. You can't turn me over to this alien jurisdiction. And Festus said, you're right. To Rome you go. So in what was essentially a fight over freedom of speech, Paul appealed to Caesar and he won. So if St. Paul could do it, if Joseph could do it, if Moses could do it, we certainly should be doing this. I mean, Christ says to be the light of the world. Well, if you don't know, how the electricity is turned on, how can you be the light of the world? And he says, render to Caesar the things that are Caesar's. If you don't know the rules that Caesar is supposed to operate by, you won't know if he's making a just claim or not. So to render to Caesar, you have to know the structure of Caesar's world. So here you've got Christ saying to do this. So as long as you are in this world, you are within this earthly kingdom, and you're going to operate within these laws. So for you to throw up the towel is really to be not compliant with Christ's command to render to Caesar, because you're ignoring Caesar or you're running from Caesar, and you really shouldn't do either.
Well, that's very compelling. Thank you for that. Okay, so one of the really interesting things towards the beginning of the book is your discussion of judicial supremacy. Now, I think most of the people listening to this podcast will be aware of the fact that the Supreme Court possesses outsized power compared to what it's supposed to possess constitutionally. They're also aware that there is a fight in the Supreme Court and in the nomination process between judges who believe that they are supposed to effectively update the Constitution for today's problems, and others who think that the role of a judge, a federal judge, is simply to interpret the Constitution properly. But you add something else which I hadn't really thought about, which is that not only is it the job of, it's not enough to just say it's the job of a judge to interpret the Constitution, because we also need to realize that even if he does intend to interpret the Constitution faithfully, it's still important that we realize that the judicial branch is not the final authority on what is constitutional, that each branch of the government is supposed to interpret the Constitution for itself within its own purview. So can you talk about that a little bit?
Sure. You've got three branches of the government: the executive, which is the president and his cabinet and all these agencies; Congress, which makes the laws; and the courts, which hears cases. Now, all officers of all three branches take an oath to uphold and defend the Constitution. Why should one of them have necessarily more power than the other? And in fact, it really shouldn't. If anything, The Constitution set up a system in which the legislature was to be supreme. Why do I say that? Because the Constitution says only Congress can write the supreme law of the land. There's nothing in Article 3 where you find how the courts are set up, which says that a Supreme Court decision is supreme over everybody else. It's not there. In fact, the only branch of the government which can formally amend the Constitution is not the Supreme Court, is not the president, it's the legislature, both with respect to Congress in proposing or the states in ratifying amendments or in initiating a convention, which hasn't happened since the first one in Philadelphia. So that is the case, and the jurisdiction of the court can be curbed and completely abolished. There's only one court which is established by the United States Constitution. That is the Supreme Court. Everything else is totally up to Congress to establish and to circumscribe. For example, there's two types of jurisdiction: original and appellate. Original jurisdiction means that a plaintiff or a defendant or a claimant gets into a court without having to go to another court. That's called original jurisdiction. The Supreme Court has that with respect to certain cases, disputes between states, ambassadors, foreign counsels, things like that. But it has appellate jurisdiction with respect to everything else. The appellate jurisdiction, if you look at Article 3, is totally subject in its entirety to what Congress decides to let the court hear. If the court is denied jurisdiction, you can't take a case up. If they're given jurisdiction, they can hear it. And again, the Congress has exercised this in the past. To give you a kind of a really strong example, after the Civil War, when you had military governments running the southern states, an editor in one of the southern states was issuing or wanted to, put some editorials out which were not very flattering with the Union government. The commanding general down there said, "You're not going to do this." And so he got into a fight with the military powers down there. His lawyer filed a writ of habeas corpus, say, "I want you to release this guy so he can, do his publishing." This is the First Amendment. The case went all the way to the Supreme Court. The case was heard in argument before the Supreme Court, pro and con. Then the court adjourns. In the meantime, the radical Republicans in Congress pass a statute, and I think they passed this one over Andrew Johnson's objection, which said, in cases like this ex parte McArdle case, which was actually heard and argued before the Supreme Court has no jurisdiction to hear such cases. Now, mind you, the case had been argued. When the court reconvened later that year, the Supreme Court Chief Justice said, "We can't render a decision because our power to hear such cases has been removed." And Justice Chase, who was from Maryland in 1799 rather, and Justice Frankfurter in the 1940s both wrote opinions where they talked about jurisdiction being circumscribed or completely abolished by Congress. And I referenced the power of Congress to do this, and I put it in some detail with a memo from John Roberts. Who is John Roberts? John Roberts is now the Chief Justice of the Supreme Court. And in the early 1980s, he was an Assistant Attorney General in the U.S. Justice Department under Ronald Reagan. He wrote a memo of which I put excerpts in here talking about the power that the Constitution gives to Congress to curb the jurisdiction of the Supreme Court. For example, there's no constitutional right to be heard in a federal court. There's a constitutional right to due process, but that can be satisfied by a hearing or a claim made in a state court. As long as you have that, the due process claims are honored. There were certain criminal cases that you could not even get into the federal system until about 1913. So for about 125 years, certain criminal cases would stop whatever was the final decision of the state Supreme Court. You couldn't go past that. So these are tools that Congress can use anytime. And in fact, I put an example of Congress actually doing this in 2004 in the situation of the effort to prevent one state from having to recognize the so-called formal actions of another state. And that happened with the so-called marriage stuff. You had a few states which initially were recognizing same-sex marriage or civil unions predominantly from court decisions, but there's called a reciprocity clause in the Constitution, which says that state A is supposed to recognize the formal acts of state B. Well, if state A doesn't recognize same-sex marriage or civil unions, Congress passed a statute, and Bill Clinton signed it literally in the middle of the night, which said that you don't have to recognize that action of the other state. So that was a federal law passed in the late 1990s. Congress, the House of Representatives, heard a bill introduced by a Congressman Hostetler from Indiana, which said there's no ability to get into a federal court to hear a challenge on this. That bill passed the House of Representatives. It went to the Senate, which was in the charge of Republicans. President Bush was the president. You know what they did? Absolutely nothing. So just because you have Republicans in power doesn't mean you're going to get a conservative policy. So you've got to watch what's going on in Congress or the state legislature. And in the book, I show you how to track legislation, whether you live in Iowa with your state legislature or Vermont or, New Mexico, doesn't matter, or how to track bills in Congress. You can do what I'm telling you about now without having to call Bob Marshall.
Right. So, and we'll definitely get to that later. Is there a category of cases that they can't do that with? I mean, presumably, the judicial system is built into our federal government. So are there certain things that they have to have the authority to do?
Well, the original jurisdiction, Congress cannot modify that. That's spelled out in the Constitution. Anything under the appellate jurisdiction, they don't have to do it. And again, Jefferson and company, he was having a fight with John Adams and the Federalist, and they didn't like the appointments that they made to the courts. Jefferson and his people, his Republican Democrats, that was the name of the party at the time, political party, they simply abolished the whole level of federal courts. So while judges are appointed for good behavior, you're only appointed as long as the court exists. The court doesn't exist, you don't have your job anymore. Now, that hasn't happened very often, but that clearly is a power that can go on. So anything under the appellate jurisdiction, Congress could say, it says with such regulations and exceptions as Congress may make, Congress could say, okay, any case dealing with abortion from a state must be passed by an 8-1 or a unanimous decision of the Supreme Court. In other words, they could put conditions and regulations on the exercise of the judicial power. So all that's doable because it's right down there in black and white. It's just going to take two things to happen. One, the citizens to know it, and two, enough citizens to contact enough congressmen to give them the chutzpah to do it.
How many congressmen do you think are aware that Congress even has this power?
Oh, let me tell you. In the early 2000s, I was up talking to a member of Congress, and you probably would know his name, but I'm not going to mention it. And I said, look, why don't you just pull the jurisdiction of the courts to hear these abortion cases? This was before Congress was doing this. Well, actually, Congress never did the abrogating jurisdiction on abortion. But he said, you can't do that. Now, this guy went to Yale, mind you, and I was in law school, but I quit. I said, yes, you can. He said, show me. So I went over and pulled this big fat book off of his shelf, prepared by the Library of Congress Congressional Research Service. I opened it up to Article 3 and read the jurisdictional statement. And he said, I didn't know that. I thought to myself, I don't think he was kidding me, but when you go to law school, you really do not learn about legislative history. You learn case law, which means it's court A quoting court B, who's quoting court C, D, and E. Unless you go back to the legislation, you really don't have the original meaning of what the statute is supposed to say. It's like taking everything second hand, third hand, and fourth hand. By the time you get down to fifth hand, you could be going exactly in the opposite direction of the original bill. So the original legislative history is there and says you can curb the jurisdiction. I think it's Federalist Paper number 81, which was written by Alexander Hamilton. The last paragraph in that essay basically says, look, if Congress gets out of line, you can yank the jurisdiction so they can't make decisions, public policy decisions in this area. So there are tools that we can have that can stop the federal courts from stopping us from doing pro-life things or real marriage things at the state level. But we haven't used them. And again, this was a member of Congress who was very high up in the kind of the seniority system, and he didn't know it.
So how do people educate their representatives in matters such as this?
You read my book, and then you ask the question. When you write a letter to a member of Congress, what you need to do is to ask questions and refer like to an article in the paper or something like that. Say, did you read this? If you simply give your view, it's too easy to get an automated response back where the congressman doesn't have to see it, and it doesn't take much staff time up. But if you say, look, here's an article on the ratification of the Equal Rights Amendment, and I want you to read it and give me your views on it, that's different from saying, what are your views on ratifying the Equal Rights Amendment 36 years after it was defeated? So you make them do something, and the best way to do it is to ask them questions about certain things. This means they have to take up staff time, and they can't dismiss you out of hand, but you have to know that.
How is it that the so-called precedent set by, federal judges effectively becomes the Constitution in people's minds, or becomes an amendment to the Constitution without an amendment actually taking place?
Because the members of Congress don't challenge it. And in part, they don't challenge it because they're satisfied with letting the Supreme Court take responsibility off their back from doing something. So they can blame Congress for doing something or not doing something and say, my hands are tied. Well, let me give an example, and I think I put this in the book. I worked for several years for Congressman Bob Dornan, and in that time I devised amendments cutting off money for the abortions in the District of Columbia and foreign aid and the Indian reservations, all this kind of stuff. Anyway, and prior to that, as a private citizen, I devised the Hyde Amendment in 1976. A friend of mine who was with the FBI, he wasn't in the FBI at that time, but he worked actually for a pro-life group called Ad Hoc Committee in Defense of Life. He did a Freedom of Information request to what was then called the Department of Health, Education, and Welfare. And he got back a response, which was kind of amazing. And he was told that this was like in late 1975, he got this back. He was told for the time period he was requesting, there was about 280 or 280 some thousand children killed by abortion with tax money. He showed this to me and I was flabbergasted. I thought, this is outrageous. One, for the abortion. Number two, to use tax money for it. And three, Congress never authorized these expenditures like this. So he gave this to me and he said, let's do something about it. So I said, okay. I went to a congressman that I had known from a group when I was in college called Young Americans for Freedom, started by the Buckley family up in New York. The guy who used to be the editor of National Review, and his brother was a U.S. senator. Anyway, I pulled him off the floor of Congress, showed him the equal response that my friend had received from the Department of Health, Education, and Welfare, and suggested that he devise an amendment on the money bill or the appropriations bill for the Department of Health, Education, and Welfare to prohibit the use of money for that purpose. So he said, there's a freshman here who might be interested in this. So I said, okay. So I gave him the documents and some suggestions for an amendment. And about 6 weeks later, I read the paper, and lo and behold, it was Henry Hyde offered the amendment on the appropriations bill for HEW. And so that started the Hyde Amendment. Now, the reason you do the budget or the money bill, especially with Congress, is because normally a bill has to receive what's called a rule to be considered. That means in the House of Representatives, which is much more structured than the Senate, you have to have permission to offer an amendment if it's an ordinary bill, like saying, well, you can't fly kites on the mall in Washington, D.C. or something like this. But on the money bills, they're kind of open-ended, and there's not normally a rule granted, so you can throw any amendment on you want, saying you can't spend money for X, or I'm increasing the expenditure for Y. So the rules don't constrict the ability to offer the amendments as much. And from 1973, the year of the Supreme Court decision on abortion, to 1976, I think only one measure dealt with abortion, and it actually was because of an amendment that I drew up for the Legal Service Corporation. That was the Office of Economic Opportunities litigation arm to help poor people, where they were helping poor people kill their kids, which I thought was, again, outrageous. And they actually did the research in the Roe and Doe abortion decisions, the background research. So the taxpayers were paying to kill kids, and they were paying to pay the lawyers to figure out how to have freedom to do the killing of the kids without any restraint at all. So again, this is all the more outrageous. Well, the Appropriations Amendment passed, and it's still law, although they've added, beyond the life of the mother, they've added rape and incest, which I didn't like, but I wasn't in charge of it, to do that. But the fact that we can get the amendment on there was interesting. Now, of course, Planned Parenthood challenged it. Now, the reason that I wanted to do a money amendment dealing with abortion was because, in my mind, Congress cannot afford to lose the power over the purse to the judiciary. If they do, what good are they? Then you're going to have unelected judges saying, well, you're going to expend money for a dam or airplanes or not, or ships or whatever. And the elected representatives of the people have no control over the budget. That's not going to happen. So what I thought is that Congress cannot afford to lose the appropriations power. And sure enough, the Hyde Amendment was challenged. A couple years go by, and the case was of McRae versus Harris. And by a 5-4 decision, that was very close. But anyway, the court agreed Congress can't be forced, compelled to spend money on abortion. Well, so one day I'm in the Capitol building, and I'm with Congressman Dornan, who was my boss, and I was one of his legislative assistants. And Charlie Rangel comes over to us. He's a kind of a lovable rogue guy, Catholic background, but just as liberal as they come. And for abortion, he fought in the Korean War, so he, military service like that for the country, but he was bad on abortion. Anyway, he came over to us, and he said, look, you guys, you know that you and I differ on abortion. And he was talking to me and the Congressman Dornan. We said, yeah, we know. He said, but I'll tell you what, he initiated this conversation, and because Rangel was part of the conference on this one bill, and Dornan was a conferee. He said, if the Supreme Court had concluded that they were going to make us spend money on abortion, that was the Hyde Amendment, he told Dornan, Congressman Dornan and myself, he said, I would have put in court stripping bills faster than you would have. Now, the interesting part here is Rangel voted against the Hyde Amendment. He wanted to spend tax money on abortion, but he knew if the court said, we're ordering you to spend money on abortion, he loses the power over the purse. So it validated my thinking that Congress can't afford to lose that, because you would even annoy the liberals on that. So the power of the purse, and again, I reference a quote from James Madison, who's considered the father of the Constitution, around this. And I give examples of types of amendments that cut off funding for various things, and I put some suggestions in there dealing with the right to life question, or the so-called same-sex marriage question.
What would be some examples of how appropriations bills could be used to blunt the effect of Supreme Court decisions such as Obergefell?
Okay, that's really simple. If you read the appropriations bills, and you can learn how to read them by reading my book, you will find that they put limits. The House Appropriations Committee puts limits on the amount of money the judges can spend for automobiles or for receptions. I mean, it's right in there. They can only spend so much money. And you have to get this in your head. The Chief Justice goes over to Congress in a committee room and wears a business suit and ask or is begging Congress for money to run the federal court system. You always think of the Supreme Court justice as wearing black gowns and he's immune and nobody touches him. There's this aura of sanctity or some etherealness. It's not there. They have to ask Congress for the money to run the courts. You got to pay the clerks, the heat, the light, the all this kind of stuff. You know, pay to buy the law books. You could say no money for a court order to a state to comply with Obergefell. Period. You could say you're not going to pay any. In others, on the appropriations bill that affects the Justice Department and the courts, you could simply state no money for any court order to compel a college to provide dormitories for same-sex married couples. You could do that. And it's perfectly legal because Congress has the power of the purse. But the citizens have to know this, and they've got to convey this then to members of Congress that, number one, I know what you can do, and I know what you can't do. So don't tell me that the courts make you do things. No, they don't. I put all these little dodges in my book that are used to fool citizens into despair. Well, you don't have to despair. I put, if there's a roadblock, I put a way around it.
It's really remarkable. I remember reading an interview with Justin Amash. He's a congressman, I think. I forget what state he's from. Justin Amash, it was in Reason magazine, and he was talking about how Congress uses omnibus bills to avoid getting anybody on the record. And in the case of omnibus bills, you know who's voting for or against it, but you just don't know what part of the bill they're supporting and what part they're rejecting, so they can be real hazy on it. But in your book, you go into so many different ways that elected officials avoid being on the record. Could you go into some of those?
Let me give you an example. Let's go to the New Testament. I think it's in one of the letters of John that evil loves the darkness. Well, there's three ways of voting. One is what's called a voice vote, where it's either on the floor of the Congress or the House or the Senate or in committee, and people say yes, yay, or nay. Then the measure passes. The second one is called a division. But again, with a voice vote, you don't know how many people are for it and how many are against it. All you know is that in the judgment of the presiding officer, either the speaker or the president of the Senate or the chairman of a committee has decided that the noise was sufficient to say that it passed or it failed. The second way of voting is called a division vote. A division vote is where, like, you'll have members stand up on the floor of the House of Representatives or the Senate, and they're counted as either for a proposition or against it, but their names are not counted. So all you know is that 219 people, voted no, and 100 and so many people voted the other way.
Is there any purpose to that kind of procedure? Is it just considered more efficient or what?
Well, some of it is to just expedite business. A roll call takes at least 15 minutes in the House. They sometimes have to hold it open, for people to make it over there. But it also allows for nefarious things to go on. The third way, the only way to get people on record, is to what's called a record vote. And a record vote means you not only know the outcome of the vote, who won or who lost, and how many people who were present and voted yes or voted no, or just voted present, but you also know the names of the people. So getting a record vote, I consider, when you're dealing with these social issues, a victory. I like to win, don't get me wrong, but at least getting people on record, either yes or no, is in itself a victory, because you then have a marker with which to judge their fidelity to your purposes or their infidelity to your purposes. That's what you have to do. You have to get a record vote. And there's so many numbers of people to require a record vote. It's normally 1/5 of a quorum.
What are some ways that citizens can engineer a record vote into happening, force someone to put themselves on the record?
Well, you can kind of back into this. You can ask them, first of all, you can ask them to put their name on a bill as a sponsor or a co-sponsor, which means they publicly have to identify, yes, I'm for this bill, or no, I'm against it. And you then can track, you can watch the votes. In other words, if if your member of Congress is on the floor and a bill comes up and somebody's going to offer an amendment, you can track this. But if you don't see in the official record that an amendment was offered, or that if an amendment was offered, not enough people seconded the demand, then you know something's going on. So you can figure this out. So the way to get this stuff is, first try to get somebody to be a sponsor of a bill, and then pledge to offer an amendment. And with Congress, there's a congressional record. So you can offer an amendment, even if it doesn't win. If your member offers the amendment, that's recorded in the congressional record, and there's a public note of it. So if you can ask your congressman, look, could you put an amendment on X to stop something from happening? And if they agree, there's at least a public record indicating, yeah, your congressman actually offered the amendment. It may have failed, but he at least went through the motions and offered it. So there are ways of tracking this from going on.
One thing I really appreciated is your brief discussion of the oath of office that our representatives take. And nobody seems to talk about this. Nobody seems to consider it important. I seldom even hear Catholics talking about it, but I remember when Ron Paul was running for president, and I was following that closely, he would often refer to the oath of office, that you're taking a sacred oath to uphold and defend the Constitution of the United States. But most people seem to think of that as a mere technicality. I mean, oh yeah, it's unconstitutional, but this is more important. And that's really disturbing. I think of the line that Thomas More says in A Man for All Seasons about taking an oath. He says something along the lines of, when a man takes an oath, it's like he's holding himself like water in his hands, and if he opens his hands, then he needn't hope to find himself again. So I really appreciated that you brought that up at all, because nobody seems to talk about it.
Well, the oath is a swearing to God. Constitution is this oath or affirmation to take account into people who are agnostics or whatever. Anyway, that's a swearing to God that you will do or not do something. Now, you take an oath of office to see that your office is, oath to the Constitution to see that your office is discharged, which means if you're voting on a bill, you really should know what's in the bill before you vote on it. Because why? You told the people you would take an oath to God to try to seek the common good. Well, if you're totally blind and don't know what you're voting on, you're not seeking the common good. You're just, someone tells you to do this, it's like a duck. And they just, push them into a line, and the duck walks down the line. That's not what government should be about. So the taking of the oath is a swearing to God that you will attempt to secure the common good. The minimum condition for which is you will read the bills and know what's in them. Secondly, the oath is very interesting. The oath is to the Constitution. It is not to a person. And if you ever read the book called The Rise and Fall of the Third Reich, you'll find out that in the late 1930s or mid-1930s, Adolf Hitler had the army take an oath, not to the German Reich, but to himself. So they took an oath, and again, it's a swearing before God, so it's an impinging on your conscience that you will obey the Fuhrer. Well, we don't do that in the United States. We say we will conform to the Constitution, because we're not supposed to have the cult of a personality doing things. So the oath is very serious, and it's kind of a necessary condition that the elected member has to say, yeah, I will use my optimum ability to know what I'm voting on and to assure that it comports with the common good. So that's why the oath is so necessary and so important.
Yeah, and that's why I like Justin Amash, because he doesn't vote on things that he hasn't read.
Right.
So moving away from the Congress itself, there are things that the states can do to further blunt unjust laws, and you talk about them as anti-commandeering laws. I'm wondering, is that the same thing as nullification?
No, it's like non-participation. Nullification was an attempt for a state to basically put a veto on a federal law. That actually, northern states tried that and southern states tried it, but that's kind of not, in a sense, doable. But you can get pretty close to that because you don't have to cooperate. And if you don't cooperate, you can blunt the enforcement of something effectively, because so many things that the federal government does depends upon cooperation with state government officials. And if the state doesn't cooperate, it hampers the ability of the federal government to do something. Now, I happen to write a law like that, and I succeeded in getting it passed, and it was just tougher than nails to do it because I had the objection of the governor for a long time. I had Ed Meese and Michael Chertoff and a bunch of people wrote a letter saying, no, don't do this, you're helping terrorists. And so I had to overcome quite a bit, but I eventually did. I guess it was 2010, the Congress had one of its National Defense Authorization Acts signed. And in there was language put in there that allowed an executive agency or the military agency to detain someone suspected of terrorism. Well, there were no definitions for terrorism. And again, anybody in an agency could say, Thomas Meares is a terrorist, and that's it. You don't get a lawyer. You're not facing a judge. You're not subject to habeas corpus. You're not even told what you're charged with. You're just detained. So I said, wait a minute, this is way beyond what you should do. So what I said, Virginia will not cooperate with that. So this is non-cooperation. And I eventually got that passed. And I also had the support of Japanese American groups because their, ancestors, in the 1940s, they were put into detention centers or compounds for no good on the West Coast for no good reason other than they were of Japanese ancestry. So they were very sensitive to this. But again, I think Virginia is the only state that passed that. I think maybe New Mexico tried it, but I know we were the first, and I think we're still the only one. But anyway, it's non-cooperation. And that's not something I made up. It basically is the result of the federal system. You've got state laws, you've got federal laws. The federal government's supposed to enforce federal laws. It's not up to the state unless the state has an agreement with the feds to get compensated. There's no requirement to support the federal law. And this actually happened in mid-1800s when U.S. Marshals in northern states were stymied by laws that the northern states passed to prohibit state officials from assisting in the recapture of runaway slaves. And the U.S. Supreme Court said that's right. They don't have to do it. And so it was called non-commandeering. And the most recent example of this was when Obama got his Obamacare passed, part of which was an expansion of Medicaid. And several states sued on that and said, you can't compel us to expand Medicaid because this is a joint federal state program. And the U.S. Supreme Court in, I guess, 2014 or whatever, upheld the states saying that, right, Congress can't force them to, in other words, they can't commandeer the states into expanding Medicaid. They can do it if they offer the money and they agree, but they can't force them to expand Medicaid. So the anti-commandeering came into play on the Obamacare bill.
So in your book, you discuss two rather foundational aspects of the way things happen in American politics, which people tend to neglect. First, the importance of primary elections, and then the importance of local politics. Now, as far as the primaries are concerned, most voters tend to vote in the general elections, but not in the primary elections. I myself have a record of voting in the primary and not in the general because I'm disappointed with what we get in the general elections. But how do we get more people voting in primary elections? I mean, it just seems self-evident that, that's how we get the poor choices that we do get, is because people don't vote in the primary elections for good candidates.
I don't know if it's the lack of publicity or if it's just people are only don't want to get involved at that point. But clearly, when you vote in a primary election, you have much more power over the outcome than when you vote in a general election, because there are so few voters in the primary elections than there are in the general elections. And it's like, if you don't like what is being served up in the general election, then enough people with the moral natural law values have not made themselves felt in the primary election. If they do, they'll have somebody in the general election that they like. If they sit on the side, if they're too busy, don't even file an absentee ballot or don't even register, God forbid, we're going to lose. So the primary election, in terms of what's important, it's like it determines what is served up to the public in the general election. So that's why you've got to vote in the primary election, or in some cases called a convention, but it's predominantly a primary.
What does the phrase "all politics is local" mean to you?
It means that people may not be concerned about overall global issues or abstract things, but they're concerned about what affects them in their daily life. In other words, I would work to get a stoplight at an intersection that was kind of crowded or there were accidents, and people would vote for me for that. They wouldn't, they weren't necessarily concerned about abortion for whatever reason, but they would vote for me for that. When I went to Richmond, I not only got stoplights to help improve traffic safety, I would vote against abortion. So whether they liked it or not, if I did something that affected their daily life, it is more impressive to people than otherwise. I'll give you an example. I guess it was like in the late 1990s, the Internal Revenue Service changed one of their revenue rulings to allow that points that you take when you buy a house, they made them tax deductible. Before that, they weren't. In other words, you have to pay these points. It was, the banks charged this, and you never, could get the money back or get some kind of tax rebate. IRS changed that. I went to the courthouse, found the names of everybody who bought houses within my district during a certain time period, who would have to pay the points and not get any deduction on their federal income tax. And I wrote them a letter explaining this ruling of the Federal Internal Revenue Service. And I will remember this just for the longest time. I was out campaigning, and I go up in a pretty nice middle-class house, and I identify myself. And this guy says, "Oh, you're Bob Marshall." He says, "You know what? You're the only politician that ever helped me get tax money back in my entire life." And he said, "Some girl came up here the other day complaining that you were anti-choice. And he said, lady, I don't care about your abortion or what. I'm voting for Bob Marshall." He got me $800. So it made an impression on him that I was trying to help him. I found this thing out about the federal government and gave it to the citizens who would have had to pay that. So they, whatever they were, these abortion people were going around doing door to door, it wasn't as effective as me getting a tax rebate for the homeowners.
So you have a lot of great advice about local politics and getting involved and how to affect things. Can you give a brief overview? We're almost out of time here, but just a brief overview of what the precinct is all about and how people can get involved. What is the most effective way of changing things in local politics, and how that expands upwards into the national scene?
Working a precinct simply means delivering a certain amount of campaign literature, whether it's for a candidate or a ballot question, to previously identified people. Unless you're trying to register new voters, you don't go to houses where there's no voters, because they can't do anything, or they're not going to do anything. Although you need to try to get as many people out, and it's a little bit of an art to try to figure out who's going to come out. So that's a little bit of a guessing game. It normally is predicted by past voter turnout. But to get people out, you have to give them a motive to come out. So you have to try to figure out what is bothering them and say that these values you hold are being threatened, or if you want to preserve these values, you have to come out and vote. And get out the vote consists of reminding people of the day to vote and the times that they're there and why they should vote. And so that occurs either with a phone call or with you putting what's called a door knocker on a doorknob, which is a flyer with a hole in it, and you put it around the doorknob, or you just insert it behind a screen door, and that's done within so many days before an election to remind people the election is coming up, and that's basically, it's called get out the vote. If you do that, you're going to increase your turnout of the numbers you need to win. You don't have to win every precinct for a candidate to win the election. In other words, cutting the margin in an area that's not favorable to your ballot question or your candidate is as good as winning another precinct, because you've closed the gap. So you don't have to win every precinct to win the election or to win the ballot.
Great. So it seems like overall, the way you've made the case in the book, of course, we can influence our congressmen and our elected officials on the federal level, but also that's not our only recourse, because the states don't have to not only does Congress not have to sort of roll over and be a doormat for the Supreme Court or any federal courts, but the states don't have to roll over or be a doormat for the Congress. And as much as we talk about the overweening power of the federal government, in the past century and a half, the mechanisms for resisting that at the local and state level are still in place for the most part, it appears, but they're just rusty and nobody really knows about them anymore.
The influence you have is kind of measured by how close it is to your home. The closer to your home, the more influence that you potentially have. So like a school board, they're more responsive to you than a member of Congress. Why? Because there are more people who are on school boards for a particular geographic area than there are congressmen. There's like one congressman for every 800,000 residents. Well, there's a lot of people on school boards for 800,000 residents, and they're more accountable to you. And you have to understand that you're on a school board, you can get elected to a county council, or you can get elected to a state legislature, and roughly half of all the people in Congress served in state legislatures before they went to Congress. So these are stepping stones. Again, the local school board can be exceptionally influential, especially with this transgender phenomenon that is still going to be run by the local school boards, either yes or no, or not doing anything, or doing something. So you've got to make sure that you understand this, that this power is, like I say, it's in direct proportion as it is close to you. Further away, less power; closer, more power.
Yeah, on that issue in particular, it does seem like it really goes by the individual institution, whether it's schools or even the corporations or local companies or national or international corporations. So actually, you have a little section on moving away from the government, on the role that corporations play in these issues. So maybe we can talk about that just briefly before we finish up.
Well, it's like if you own stock, you can get invited to a stockholders meeting and you can complain about policies. Like, if you don't like, the way some of these people are treating the environment, or if they're making abortion pills, you have a right to vote. But you don't have a right to vote if you don't step in and buy the stock, or, do what's necessary here. So where you spend your money is where you can vote for your public policy. And if you've got stores that are out here supporting amoral policies, then you need to try to figure out some other place to shop if you can do it.
Yeah, I think some people feel a bit paralyzed because we have so many corporations that are so huge. I mean, and you list earlier in the book all of these huge corporations that supported gay marriage. I forget the exact circumstances under which that occurred, but I'm sure a lot of those corporations are connected, and some of them are owned by others, and everything, it just seems so centralized in our commercial life now that it's hard to avoid, shopping on Amazon, for instance. But I guess we have to pick the ones that we can do without.
Pick the fights you have a chance of making a mark. Whether you win or not is in one sense secondary, but making people pay dearly for what they're doing may make them think twice before they do it again.
Okay, great. Well, that was a great conversation. I learned even more, and I'll definitely encourage people to check out the book, which is Reclaiming the Republic. So thanks a lot, Bob, for coming on the show.
Thank you, Thomas. Thank you then. Bye-bye.
This week's readings are just 3 little tidbits from the great English legal tradition. The first is from the 13th century legal theorist and cleric Henry de Bracton. The law makes the king. There is no rex where will rules rather than lex. And the other 2 are from St. Thomas More, the first of which is famous from having been paraphrased in A Man for All Seasons. Were it my father on the one side and the devil on the other, his cause being good, the devil should have his right. That's from his son-in-law's biography of him, and the other one is from his Utopia. You must not abandon the ship in a storm because you cannot control the winds. What you cannot turn to good, you must at least make as little bad as you can. And that's sort of the spirit of much of what I talked about with Bob today. Of course, we are aiming for an absolutely good outcome in politics, but there's also a great deal to be said for simply making as little bad as we can. All right, hope you enjoyed this episode, and I'll see you next week.